Hi everyone, my name is Edward Tabet-Cubero, and I've had the opportunity to engage in the Yazzie Martinez versus State of New Mexico lawsuit for the past several years. I'm a former classroom teacher. I was a bilingual teacher in southern New Mexico, former school administrator, and more recently worked as the executive director of the New Mexico Center on Law and Poverty. And I'm happy to be here with you to share some of an overview of the Yazzie Martinez versus the state for the New Mexico Council for Teachers of English. So I'll walk through the mechanics of the lawsuit, who were the plaintiffs, defendants, student groups represented, some of the outcomes, and hopefully then you can begin to draw some more clear conclusions about the connection between the lawsuit and your school or particular classroom. So we know that in New Mexico, we have a distinctly diverse student population, right? 3/4 of our students in New Mexico are culturally and or linguistically diverse. In fact, about 36% of our families in New Mexico speak a language other than English. And we all see that diversity as a rich asset. We're not only proud of that as New Mexicans, of that diversity, we also know from research that building upon that diversity helps students learn better. And the challenge is with that diversity that in the state with the lowest of low achievement, and we've all heard 50th way too many times, but in the state that's ranked 50th, there are certain diverse student groups that are suffering from these chasmic achievement gaps with their white or English-speaking peers. And so we know that English language learners, for example, suffer from a 36-point achievement gap in reading with their English-speaking peers. We know that Native American students have about a 25-point achievement gap with their white peers. Students with disabilities are also close to 30 points in their achievement gap as well. So we know that the situation is dire. And in fact, the situation in 2014 became so dire that not one but two lawsuits were filed, Yazzie and Martinez. They were eventually consolidated, and I'll walk through that. Because I served as the executive director of the New Mexico Center on Law and Poverty, I'll spend most of my time on the Yazzie side of the case because they represented and still represent the Yazzie plaintiffs. But I will talk through the overlap and similarities and coordination with the Martinez plaintiffs. So let's jump into the case. Both cases were filed in the First Judicial District Court, so in court in Santa Fe in 2014. And both cases made a very simple claim. There is one sentence from New Mexico's state constitution of 1912 that says this: a uniform system of free public schools sufficient for the education of and open to all the children of school age in the state shall be established and maintained. So this entire Yazzie Martinez case that lots of you have began to see the impact of was really based on one clause in our state constitution. And the words in that clause that were really debated over the period of about 3.5 years were uniform and sufficient. What do we mean by uniformity and sufficiency? The uniform piece, I think, is pretty clear, and educators can really relate to this, that in New Mexico, we've developed this patchwork system of haves and have-nots. We have some real bright spots of excellent things going on, and lots of support and programs and services. And then we have other places where students don't have equitable access to those types of supports. I'm sitting right here in our office, I'm looking at a high school outside here that has a robust set of social services that are offered to all students. They have social workers on staff, they have counselors on staff, they have community partnerships developed so students can get access to healthcare, to mental health support, all of the things that they might need to mitigate the impact of poverty on their learning. A mile down the street, there's another high school with staff that are working just as hard, but they don't have these programs. Students don't have access to social workers, counselors, nurses, those sorts of things. And so, those disparate inputs lead to disparate outcomes. Elementary school down the street, there's a great pre-K in there, high quality bilingual pre-K. Similar demographics at a school just down the street from it, and there's no pre-K program. Again, we have not created a uniform system in New Mexico. We've created this patchwork system of haves and have-nots. And so that was part of the impetus for this case is to bring uniformity to the system. When it comes to sufficiency, that term was argued for a long period of time by both plaintiff and defendant attorneys. And here's essentially the case that the plaintiffs made around sufficiency. So first, New Mexico has defined sufficiency within our state legislature over the years. We have some of the most supportive, progressive education policy when it comes to minority learners in the country. So we have one of the country's only Indian Education Acts that calls for the closing of the achievement gap for Native students by using culturally responsive instructional materials, by training teachers up on how to effectively serve Indigenous students, by providing Indigenous language instruction, by schools and tribes working in partnership and in consultation with one another. All of those things are promises that our legislature and our former governors have made to our students. We have, in a similar vein, one of the nation's only Hispanic Education Act calls for the same thing, closing of the achievement gap for Hispanic students, following similar strategies of linguistic and cultural responsiveness and a commitment to closing that gap for our Hispanic students. And then very uniquely, we have the nation's first funded bilingual multicultural education law. And so our Bilingual Multicultural Education Act actually calls for all students to have the opportunity to become bilingual and biliterate. That's a goal, is biliteracy, and to be at grade level in all of the other content areas. And it's incentivized for districts to provide those types of programs through increased funding. The challenge to implementing those programs, as we know, is there are 8,000 teachers in our state right now who have English language learners in their classroom, and they don't have a bilingual or TESOL endorsement. They haven't had the opportunity to get that training that they need. And so there are significant gaps in the support that we're providing our teachers to be able to offer these programs that the state has promised to our students. So those are the types of things when we're talking about sufficiency that we mean, the social service supports that I talked about as well. And then sufficiency when it comes to funding. The state legislature actually commissioned a study in 2008 by the American Institutes of Research, AIR, and that AIR report in 2008 found that New Mexico was underfunding our schools by about $336 million at the time. You fast forward to kind of the middle of the lawsuit in 2016, that $336 million equates to over $600 million. As you all know, our state legislature appropriated about $480 million new dollars to public education last year, which was a start, but we still haven't even reached our 2008 spending levels as a state. So let's walk through the basics of the lawsuit. Again, it was filed in the First Judicial District Court in 2014. The Yazzie plaintiffs filed, the Martinez plaintiffs filed, and the judge said, wow, you all are making very similar arguments. They're all based on this constitutional claim. And so she consolidated the two cases into Yazzie Martinez. The Martinez side was litigated by the Mexican American Legal Defense and Education Fund out of their San Antonio, Texas office. They represent the Martinez children from Albuquerque, as well as about 50 some odd other families from every corner of the state. And the Yazzie plaintiffs represent 5 families, as well as 6 school districts, including Rio Rancho, Gallup, Lake Arthur, Moriarty, Santa Fe, and Cuba school districts. The defendants are the state of New Mexico, including the governor, the New Mexico Public Education Department, and the Secretary of Education. It's really important to understand who the defendants are in the case. The defendants are the state, meaning the entire state of New Mexico. And oftentimes we're seeing under the last administration, teachers being blamed for the situation. The plaintiff's intent is to support teachers with this case. We've seen even recently school districts getting the blame. Well, school districts are the plaintiffs in the case, claiming that the state has actually failed in its obligations to provide sufficient funding and programming and support to school districts. And so it's just important to keep that clear. The basic legal claim, as I've mentioned, is the defendants have violated the state constitution. And the two cases were consolidated and went to trial over the summer of 2017. The trial lasted 8 weeks. I'm really proud of the fact that the plaintiffs put forth a set of expert witnesses who were local experts with national reputations from right here in New Mexico, who have taught in New Mexico, who have served as social workers or still serve as social workers in New Mexico schools, who have taught English in our schools, compared to the defense plaintiffs who were contracted from different places from out of state and have spent very little time in our classrooms in New Mexico and demonstrated a minimal understanding, I think, of the situation on the ground in our classrooms. So case went to trial, 8-week trial, and essentially the plaintiffs made the case that our students in New Mexico are just as capable as students anywhere else in this country. They have just as much potential. They're just as intelligent as their peers across the country. Our teachers are just as qualified, just as committed, just as talented as teachers anywhere else in this country. Our parents value education. Our parents are committed to their children getting the best education possible. And so if it's not the fault of some shortcoming of our teachers, our students, our parents, then why are our achievement rates at where they're at? Because there's a broken system that's not uniform and not sufficient. And the judge in 2018, a year after trial, sided with the plaintiffs and said, yes, indeed, you're right. You've proven that we know what works. You've proven that the state of New Mexico is not providing what works. And the judge gave the defendants essentially one legislative session with a deadline to come into compliance with the Constitution. So here's the key takeaways from the court's decision. The court said New Mexico children have the right to be college, career, and civics ready. All children do. That the state has violated students' constitutional rights. This is key. Lack of funds is no excuse. We know what works. And then gave this deadline of April 15th, 2019, which has come and gone. We saw with the governor and the legislature's moonshot last legislative session, their education moonshot, a start to begin to come into compliance with the Constitution. But both plaintiff groups have actually called the defendants back to court over the past few months, late 2019, early 2020, to begin to make the case that the state is still out of compliance with the Constitution, not providing students and teachers the support and the resources that they need to fully be successful. Oftentimes, and I'm sure you all hear this as advocates, I know myself I do, when we're presenting ideas to elected officials, they'll say, well, there's limited resources, so out of this list of 10 things that you think ought to happen, what's your priority? Well, here's what the court says about asking that question with regard to priorities in education. A sufficient education is a right protected by the New Mexico Constitution. As such, it is entitled to priority funding. Supporting an opportunity for a complete, proper, quality education is the legislature's paramount priority. Competing priorities not of constitutional magnitude are secondary, and the legislature may not yield to them until constitutionally sufficient provision is made for elementary and secondary education. That is a really significant statement where the judge is saying out of all the things that the legislature appropriates funding for, the only one that rises to the level of a constitutional claim is education. And you have to fund education first, and everything else is secondary to education. And so that is written into her decision, and it is a really good tool now for advocates to continue to push for the legislature to prioritize all things education first. The second thing that's really important to understand about the judge's decision is this. There are about 24 school funding cases around the country. Many of them have sided on the side of the plaintiffs, basically saying that the states failed to provide sufficient funding for schools. New Mexico's case is actually very different from those cases because funding was actually secondary in many of the arguments and in the court's decision. What the experts in the case claimed was, we're not providing sufficient resources, programs, and services that our students and our teachers need to be successful. So we need to identify and provide those first and then fund them. So here's what the judge says, A, B, and C. A, the defendants have failed to provide at-risk students with programs and services necessary to make them college or career ready. B, the funding provided has not been sufficient for all districts to provide the programs and services required by the Constitution. And C, the public education department has failed to meet its supervisory and audit functions, essentially to ensure that the money intended for these programs and services actually reaches the students and gets implemented in an effective way. So identify the programs and services students and teachers need, fund them, and then provide oversight and support to make sure that they're implemented with quality. So that's the essential structure of the court's decision. Important to all of that, and I'll go back to my opening comments about the unique diversity of our state, is that the entire set of arguments and the entire decision was grounded in a multicultural education framework, acknowledging that our multicultural nature as a state is an asset. And research is very clear that if we invest in that asset, students achieve at much higher rates. And our legislature has made a series of promises through the Hispanic Education Act, Indian Education Act, and Bilingual Multicultural Education Act that they've failed to deliver on when it comes to bilingual and multicultural education. And so the implications of that are that the remedies that are now developed to fix what's been broken in our system are all based in that diversity and multiculturalism. So post-lawsuit, a small handful, 2 or 3 broad community-based coalitions have emerged. The one that I've been most active with is called Transform Education New Mexico. You can Google them or find them at transformeducationnm.org. And Transform Education New Mexico basically brought together 20 kind of key advocacy groups in the state, including both teachers unions, bilingual education advocates, Indian education advocates, the School Boards Association, superintendents, school administrators, and so on, all under the same umbrella to work with community to develop a set of remedies. So over a series of convenings, we developed a 36-page remedy platform to make recommendations to the state on here's how you fix this broken system. That remedy platform has a big chunk that involves instruction, another chunk that involves teacher retention, meaning professional development, pay, those sorts of things, as well as teacher quality pre-K and early childhood services, social services that I've mentioned, and then that it's kind of wrapped around by sufficient funding and accountability, oversight, and support. Those remedies that have been recommended essentially were high level, encompassed in those categories in 36 pages. They're based in research that was presented at trial and proven to the judge, and the judge agreed with. And now those broad-based ideas are being turned into actually legislative recommendations. So last session, there were several bills up, a handful of them passed to remedy the lawsuit. And this session, that work continues, and that work, I'm guessing, will continue for several years. But big buckets of what we know works are things like access to social services for our students to mitigate the impact of poverty on learning. Last session, we were successful in getting, for the first time, funding for community schools initiatives, which is really exciting. That funding is rolling out into districts as we speak. Bilingual education, bilingual multicultural education programs. There's 40 years of research to show that if you put an English language learner in a bilingual program and another English language learner in an English-only program, their achievement, particularly in reading, will track about the same through about 3rd or 4th grade. And eventually that student who's placed in English only will fall off a cliff achievement-wise, unfortunately. And the student in the bilingual program will actually, over time, by about middle school, close that achievement gap with their English-speaking peers. So social services, bilingual multicultural education, access to universal access to high quality, linguistically and culturally responsive pre-K, and then smaller class size and extended year enrichment programs. And we know there was lots of operational issues with rolling out K5 Plus and extended learning last year. those are the types of programs that we want to see continue to be funded, but operationalized in a much more supportive way coming out of the public education department. And those programs need to be enriching and not remedial. On that note of remediation, and I think important to this particular audience, our expert witness in Indian education visited and did an in-depth study on 6 school districts in New Mexico that had the highest percentage of Native American students there. And here's what they found. The number one intervention that was provided for Native American English language learners was remedial reading programs. And we know that language issues are not reading issues. Yes, there's some overlap, but first you need to treat the language issue, which means you need to provide a comprehensive English language development program. And that was not happening in these schools, and it's not happening in many schools across the state. And instead, students were just being plopped into remedial reading programs, expecting reading intervention to fix a language issue. And so those are the types of things that we need to do a better job as a state of getting training on for teachers and administrators, and then resourcing so that students can access language and have high quality reading instruction and then intervention when is needed. So that's the type of thing we're trying to accomplish. I'm just going to run down a quick list of the types of remedies that have been turned into legislative proposals. First one would be to make our at-risk index equal to 25 to 50% additional funding for at-risk students. New Mexico, prior to last session, had one of the lowest at-risk funding indexes in the country, and we were successfully able to increase that significantly, but we're still not to the place where experts say we ought to be, which is at-risk students ought to generate an additional 25 to 50% funding compared to non-at-risk students. Fully fund the 3 acts that I've been talking about: Indian Education Act, Hispanic Education Act, and Bilingual Multicultural Education Act. Increase the capacity in higher education to meet the needs in K-12, particularly with Indian education programming and bilingual education programming, closing that gap of teachers that haven't had the opportunity to get a bilingual or TESOL endorsement. Compensating educators adequately. So since last year, our coalition has been pushing for minimums of $45,000, $55,000, and $65,000 on salaries, plus 10% for all others. That push will continue, and it will continue to increase as the years progress, but we need to compensate our teachers sufficiently. Fully fund special education services and improve delivery. Fully fund universal pre-K that's culturally and linguistically responsive. Extend the school year. Provide access to integrated student supports for all. Prepare more bilingual and TESOL teachers better. Provide all teachers professional development in multiculturalism and multilingualism. Second language acquisition. Provide sufficient funding for high quality instructional materials for all of our teachers. Improved funding, increased funding for technology and transportation, and then develop and implement a statewide approach, not just to literacy, but to biliteracy, and support all teachers with what that might look like. So those are some of the remedies that the advocates kind of coming out of the case are working on. What you'll see over the next few years is probably kind of more court activity with defendants claiming that they've met constitutional sufficiency, plaintiffs claiming that they haven't until they do. The legislature trying to figure out how they can better appropriate funds and target those funds at the programs that are needed. And then the executive branch hopefully supporting school districts and classroom teachers in implementation on how to best support our diverse students in New Mexico. So hopefully this overview helps you all. Please feel free to reach out to the folks listed on the Transform Education New Mexico website, or contact your organization's leadership to get a hold of me, and I'd be happy to talk with you further about Yazzie Martinez versus the state of New Mexico. Thank you.